Hi, so I'm Katja Drnovšek. I'm an assistant at the Faculty of Law in Maribor, and I'm active in several subjects, which include family law. I'm also a PhD researcher here, and Professor Suzana Kraljic was kind enough to let me know of your conference. So I would like to thank you for the organization and for having me here. Now, Slovenian legislation in the area of family law underwent a reform recently, and many aspects and many concepts have changed. Today, I will focus on the concept of parental responsibility under the new regulation. I will just start by giving a short introduction in what actually happened. So, Slovenian family law was centered around Marriage and Family Relations Act for a long time. But this one was adopted already in 1976, still in Yugoslavia. It was later amended a few times with some amending acts and with some other acts that had some provisions like Notary Act, Civil Procedure Act, and so on. But it's clear that after all this time, the regulation was not really sufficient anymore. It did not follow modern challenges, modern legal developments. Our constitutional court even decided that some provisions were unconstitutional, and there were several problems in practice. So there were many attempts to reform the family law in a more systemic manner. And in 2011, there was a proposal for a new family code, which was drafted and adopted after a lot of discussion. But there were some problems, and then there was a referendum because, as the previous presenter said, we had a similar situation in Slovenia. We wanted to change the definition of the marriage to two persons, to a union of two persons, and this was seemed problematic by a part of the broader public. So there was a referendum about the family code, and it was not adopted because of that. So what happened was that some of the problematic issues were regulated in separate acts. They were left out of our family code. And there was a new proposal for the family code without those issues. So in 2019, our family code was actually adopted. It left out the definition of marriage as the union of two persons and kept the definition as a man and a woman. But I want to emphasize that this does not mean that this is not regulated. We have separate acts now for those issues. Like we have a separate act that regulates same-sex partnerships, and we have a separate act that regulates family violence, domestic violence, because those were some of the issues that were problematic. So as soon as the family code left out those issues, it was adopted now. So since 2019, we have a whole new regulation with many changes in the area of marriage, of relations between parents and their children, adoption, foster care, measures to protect the best interest of the child, and so on. There was also a new non-contentious Civil Procedure Act, which followed, and it regulated the procedural aspects of all of this. Now I will focus on one concept that was somehow changed out of many, which is the parental responsibility. This concept replaced the concept of parental rights, which was valid before, and I will explain all of that. So under the previous regulation, this Marriage and Family Regulations Act, which was valid before, parental rights were basically defined, as you can see on this slide, so as the rights and obligations of parents to ensure through direct care by their work and social activities the successful physical and mental development of their children. This is a consequence of our constitutional regulation of parental rights and obligations, according to which the parents have the right and duty to maintain, educate, and raise their children. And this right may only be revoked or restricted if there are reasons provided by law for that and in order to protect the child's best interests. These constitutional rights and obligations are basically reflected in three types of rights in our family law provisions. The first one is these parental rights or parental responsibilities. The second one is the right to maintenance, which is considered separate from that. And the third one is the right to contacts. So those are separate rights in Slovenian legislation. which means that if someone loses the parental responsibility, if it's withdrawn, they might still have the obligation to maintain their children or the right to have a contact. Now, when the legislation changed, one of the reasons why they focused also on these parental rights was terminological. So you don't know Slovenian language, so I will just explain this shortly. The previous expression, parental rights, is translated as roditeljska pravica in Slovenian. Roditeljska derives from the word to give birth, or a person who gave birth. So it actually implied a parent who is a biological parent to the child. It would not cover, terminologically, it would not cover someone who adopted a child, adoptive parent, which was considered too broad. So the new term parental responsibility is translated as starševska skrb. And starš, which is the word that this expression derives from, means a man and woman with children. So it's broader. It's a parent, but anyone who has children. So this also includes adoptive parents and other type of parents. So this is the first, in Slovenian, this is a much more noticeable distinction now than in English, because it still says parental, but in Slovenian we also have those two words for a parent. And the second reason was because, as you can see, previous was parental rights, and now it's parental responsibility. The reason is because some parents understood the word right in somehow possessive way, as if they have the right to their children, as they're in some way their property, and they can decide about whatever they want. But of course, parental rights refer to parents' duties and obligations as well. This is the main reason why parents have parental rights, to take care of their children and their interests. So the new expression now is more child-oriented, and it also implies that the parents also have the obligations in the word, which before it didn't. And this new solution is also more in line with international acts on parents' rights and obligations, such as Brussels IIa regulation and so on. B's regulation and so on. This is one of the reasons why the expression changed. The contents itself, the scope of parental responsibility has not changed as much. It is still seen as the entirety of obligations and rights of parents to create, in accordance with their capacities, conditions for the comprehensive development of a child. And the law now derives from this parental responsibility the parental obligations, which are defined as obligation of parents to care for the life and health of their children, provide safety, basic care, upbringing, and supervision, provide their children with conditions for healthy growth, balanced personal development, and independent life and work, maintain their children, and within their powers, provide for the schooling and professional education of their children according to their capacities, talents, and wishes. Now, this is a very broad definition of parental obligations. Of course, they are defined in more details in other provisions. So the scope has not changed as much, but the family code did regulate some parts, some aspects of this parental responsibility in completely different ways, and I will focus on those because they are more in line with modern developments in law than they were before. So the first aspect that I would like to address is a shift that happened towards the preference of joint exercise of parental responsibility when the parents no longer live together. So parental responsibility is intended to be exercised by both parents in the best interest of the child, of course. Now, if the parents no longer live together, then of course this has to be decided who does what, who can decide on what. And under the previous regulation, the joint custody was an exception. So the parent with whom the child lived was supposed to take care of most of decisions, but now this changed. So now parental responsibility is supposed to be exercised by both parents together, even if the parents no longer live together. And it's decided that the parent with whom the child lives in custody decides on issues regarding the child's everyday life and the child's permanent residence, but both parents decide on issues that are critical for the child's development by common agreement. So they have to agree on everything else. Of course, they have to do everything in the best interest of the child. So now this provision actually promotes joint custody and parenthood even if the parents no longer live together. and only if they cannot decide and if it's not in the child's best interest, then this is changed. So as a rule, it should be joint custody if it's possible at all. If the parents cannot reach an agreement, they are first assisted by a social work center or a mediator if they require so. And if they still fail to reach the agreement, only then the court jumps in with their solution. So this was the first shift. Now joint custody is kind of a rule. Regarding the termination of parental responsibility, these rules have not changed as much because as a general rule, the parental responsibility terminates when the child reaches the age of 18, so when they attain the age of majority. There are two exceptions. There were also exceptions before, when the termination of parental responsibility happens sooner. The first one is if the child gets married when they're at least 15 years old. This can happen if the court approves the marriage. So they have to be at least 15 years old. And if they are not yet 18, the court needs to approve the marriage. And they only do that for justified reasons. And if the child has adequate maturity to be capable of independent life, in that case, they gain full capacity to contract when they get married, and the parental responsibility ends at that moment. Or another reason is if the child becomes a parent, and the court also again decides that the child has reached adequate physical and mental maturity to be capable of independent life. In that case, parental responsibility also terminates at that moment. But there is this has not changed much, but there was a huge change regarding the extendability of parental responsibility. Because under previous regulation, the court had the authority to extend parental rights, so before there were parental rights, beyond the age of 18, if the child was determined to be incapable of taking care of their interests, their rights themselves, for reasons of physical or mental disabilities. So the parents had to provide a proposal, or the social work center submitted proposal. This provision was heavily criticized because it also included the reason of physical disability. So if the child had physical disability, the parental rights could be extended, which means that the parents decided a lot of things for them. They could be mentally capable of deciding for themselves, but they could still be there could still be this extension of parental responsibility. Such persons basically had the same legal status of a child who reached 15 years of age, which means that the parents had to provide consent for important decisions, or they even had a status of a child who has not yet reached the age of 15, in which case they were not able to conclude any legal transactions on their own. So it was already criticized in practice and by theory that this was an unjustified infringement or encroachment in their personal life, because the parents also kept the right to take care of their upbringing, including like moral upbringing, religious upbringing, and this is kind of a large infringement in personal life. So under the family code, the interests of adult persons who are not capable of defending their own rights and interests, only for a reason of mental development disabilities or mental health problems, now there is no longer physical disability, they are protected by the institution of guardianship instead. So only if they are mentally incapable to decide for themselves and take care of their own interests, they are protected by guardianship, and the court has the authority to decide who the guardian should be, not necessarily a parent, and they have to specifically say which legal transactions have to be concluded by a guardian. So only the things that the person cannot do themselves mentally is now decided by a guardian in accordance with the principle of proportionality. So this was a large change, but the parental rights cannot be, the parental responsibility cannot be extended, but the person is instead placed under the guardianship. As I mentioned before, the Slovenian constitution says that the parents' rights and obligations can only be revoked or restricted if such reasons are provided by law and if this is in the best interest of the child. This is also, so only if the parents do not take care of the child's best interest can measures be implemented that protect those interests. Under the previous regulation, social work centers and the courts had a lot of several options to protect the child's best interest, But it was all stated in such a broad manner that there was no clear hierarchy, which measures should be implemented, what are the reasons. The social work centers had some discretion, courts had some discretion, and this was all very problematic in practice. So the family code now regulates these measures in a more comprehensive and systematic manner. It basically provides the list of all the measures that are available, the reasons why they could be imposed, maximum duration, how they should be monitored, who has the jurisdiction in which case, and so it's now much more clear. There are basically 3 types of measures that may be issued. Let me just see. Yeah, okay. So there are basically 3 types of measures. The first one are interim injunctions, which can be provided by, which can be imposed by courts. There can be emergency removal of a child in urgent situations, which can be done by social work centers. And there are measures of more permanent nature, which again can be done by court, and everything is defined in much details. So, as regards to parental responsibility, the most difficult for the parents, so the strictest measure is the withdrawal of parental responsibility. Now I need to emphasize that these measures are not intended to punish the parents, but to protect the child. So the courts have to follow the principle of the least restrictive measure that would still protect the child's interest, but would also restrict the parents' rights in the least restrictive manner. So the withdrawal of parental responsibility is the most restrictive measure, and it should only be implemented if nothing else would suffice to protect the child's best interest. So the court may withdraw parental responsibility from one of both parents only if the child is endangered, or if the circumstances of the case indicate that there is little likelihood that the parents will be able to resume custody of the child. So this measure would only apply, for example, if the child's physical, moral, or intellectual development would be at risk, like if the parents would be abusing them physically, sexually, emotionally, if they would force them to participate in some criminal activity, if they would force them to work when they're still young. So only in these kind of cases. Under Slovenian legislation, it's not possible to collectively withdraw parental responsibility, so the court has to decide for each parent and for each child if they still retain the responsibility or not. It could happen that a parent would be abusive towards one child and not the other, so in this case, only the parental responsibility towards one child would be withdrawn and not to the other. If the parental responsibility is withdrawn, the court places the child with another person in foster care under guardianship, depending on the situation. But the parents still have to pay maintenance because, as I said, those rights are separate. They could also still have contacts, technically, but in practice, the reasons for withdrawal of parental responsibility are so strict that this would rarely happen. But the court will have to decide on those aspects as well. This measure is not limited in its duration and it's intended to be permanent, but the law does allow, if the situation would change a lot, that the court would reinstate parental responsibility, but again, in practice, this would not happen very likely because of how strict the reasons are to withdraw it. If the child's best interest can be sufficiently protected without parental responsibility being withdrawn, the court can restrict it instead, in which case the court would actually have to decide which aspects of the parental responsibility no longer applies, so which rights the parents no longer have. This would, for example, happen if the parents were addicts or gamblers and would be irresponsible with how they manage the child's property. Then the court could restrict their parental rights only for the part where they manage the child's maintenance and appoint the guardian to do that instead. Now, this measure is limited in time. It can last up to 1 year, but it can be extended if this is necessary for the children's best interest, but the court has to decide it in each separate case. Now, just to illustrate, there are other measures of more permanent nature, which include a decision on medical examination or treatment, restriction or withdrawal of the right of contacts, removal of a child from parents, or placing a child in an institution. These are other measures of more permanent nature. So I only focused on the ones that have to do with parental responsibility. And one last thing that I want to mention is a completely new institution of granting parental responsibility to a relative, which was introduced into Slovenian legislation. We had this one notorious case, which was the reason why this was adopted. So in 2015, there was a family tragedy in Slovenia where the father of 2 children murdered their mother and had to be put in prison, of course. So the children were basically left orphaned. Their grandmother, who took care of them at that point, asked to be their foster parent, but she was denied that because it was not considered to be in the best interest of the child. Now, the Slovenian legislation does not allow for direct relatives, for close relatives, to adopt children. So grandmother is not allowed to adopt children because that is supposed to confuse family relations, affect succession in negative way, and so on. So adoption is not an option. Relatives can only be foster parents or legal guardians in such cases. But because grandmother was not supposed to be proper foster parent, she was denied this option. And the social work center also did not really took care of this in a sensitive manner. They actually took the children from the kindergarten without notifying the parents. It was all very traumatic. So the media made a scandal out of that, and something had to be done. So because adoption was still not considered the proper solution, the legislator decided to include this new institution of granting parental responsibility to a relative, which basically is similar to adoption, but it can be done by persons who cannot adopt the child because they are close relatives. It's very narrow in scope, so there are very strict rules. So first, the parental responsibility can only be granted to a relative of child whose parents are no longer alive. So both parents have to be dead. This has to be in the best interest of the child. The relative also needs to be at least 18 years old and at least 18 years older than the child, except in certain exceptions. And they also have to be suitable personally. They should not be sentenced for some criminal acts or something like that. So this is now intended for close relatives specifically because of that case. Now, this person becomes child's legal representative, has the same rights as parents, but there is no right to succession between the child and this person who has been granted parental responsibility. So these were a few changes that I wanted to mention. This is all new and different from what we had before. We have not had this regulation for long enough to say if this is working better in practice. We will have to see what the case law says, what happens in practice. But the theory is kind of mainly in agreement that this should protect the child's interest better now, and that this is more in line with modern developments of family law. So we will see what actually happens. So this is it for my presentation, and thank you for your attention.